Welcome to the Commercial Awareness Compass. This is your weekly guide to developing your commercial awareness in a way that goes beyond just the news. Each week, we break down one major story, breaking it down to help you build your understanding at 3 levels: beginner, intermediate, and advanced. We'll break down today's story in a way that's easy to follow and gives you practical insights to use in your applications and interviews. I'm Tori, I'm a future trainee solicitor, and I'm joined by Henry, a corporate lawyer and content creator. Today's session, we are going to focus on Google and online advertising technology. So as we go through the beginner, intermediate, and advanced levels, please keep an eye out for how each explanation builds on the last. We'll start by understanding the basics, then we'll think about how businesses and industries are impacted, and finally, we'll think about the strategic thinking that goes into helping clients navigate these challenges. So we'll start with the beginner level. Henry, could you please set the scene for us and explain more about the story that we will be talking about?
Yeah, for sure. Thanks, Tori. So we're going to be talking about the recent decision by a US judge, which held that Google is holding monopoly in the online advertising technology space. And this comes off the back of a lawsuit from the Department of Justice in the US alongside 17 other US states. And it found that the courts found that Google had been engaging in anti-competitive practices that has harmed publishers, competition, and consumers. This is a relatively fresh announcement, and we've heard from Google that it is planning to appeal this decision. So that, again, awaits to be seen, but we're going to break down where we're at to date in terms of the impact on competition.
Sweet. Thank you for outlining that. Then I think really the first question I have is just about this idea of competition. So really, for the benefit of our viewers / listeners, could you just explain kind of what competition law is, why this anti-competitive behavior would be problematic?
Yeah, for sure. So at its most basic level, competition law and the regulatory remit around it, this is in a broad sense, not specific to the US and the UK or the UK, is that ultimately competition law is there to encourage fair competition against amongst sort of key players within certain industries. And what the regulatory remit is basically trying to avoid is having one key player, which you may have seen written down or described as being a monopoly within a certain industry. So if that organization holds a monopoly, it then impacts what is available for consumers in terms of choice and options available to them. So the competition law regime tries to make sure that the playing field is basically level so that everybody kind of stands a chance and that consumers aren't negatively impacted by that.
Mm-hmm. Okay, thank you so much for explaining that. And then I had one other question at the beginner level so far, which is just kind of about the broader context of this. So we're talking about this specific instance related to Google, but is this perhaps part of a bigger trend that could be relevant to other companies as well?
Yeah, 100%. So if we just to come off the back of the competition law breakdown and to kind of put that into context in terms of this scenario. So what we've seen is that Google has been deemed to have a dominant position. It's just the phrase that the courts have used in the online ad tech space. So they would be seen as being anti-competitive because the reason that they said this is happening is because Google is controlling the demand aspect of the kind of the chain, which would be the advertisers, the supply chain aspect of this, which would be the publishers, and also the market infrastructure, which would be the ad exchanges. And I'm not an ad tech specialist, but they're like the key parts of the sort of the jigsaw. And with Google having a dominant position in all three, that's been deemed as anti-competitive. And then in terms of the broader, you mentioned, or you asked, sorry, about the global sort of trend in terms of big tech and this space, I think that we are seeing, particularly if we look at a lot of the headlines in the US quite of late in terms of Meta and TikTok and now Google, we are seeing a global trend of sort of increased scrutiny on these big tech companies, Amazon, Apple, Meta. I think there's a big one with Apple on it at the moment, actually, across Europe and America for anti-competitive behavior. and we're seeing that there's increased scrutiny in this space. And then as a result, there's going to be more legal work in these sectors in terms of compliance, investigations, appropriate policies, and what these organizations should be doing. And I think we're seeing these now because these huge companies, when you think of like big tech, we all just go Amazon, Apple, Meta, Google, and these organizations hold arguably monopolistic spaces within the sort of areas that they operate. So I think we're going to see a lot more challenges to come.
Mm-hmm. So I think that's a really helpful outline at the beginner level, because so now we have this understanding of, what competition law is really in essence. And then also I think for anyone at a beginner level of their commercial awareness, it is helpful to be able to recognize when something is part of a bigger trend, because then also you can apply the things that we're talking about here to a different scenario too. Because we're talking about Google today, but there are these other, as you mentioned, other big tech giants to think about as well. So if we move on then to the intermediate level, at the intermediate level, this is really why, when we're thinking a lot about why law firms care, why businesses care. But something I thought would be helpful for us to start with here is because the case that we're discussing right now is a case in the US. So could you explain a little bit about what the implications could be or the relevance could be for the UK or for lawyers, aspiring lawyers in the UK?
Definitely. I do just want to add though on the point that you flagged, Ari, if we the global picture or the wider picture of this in terms of applications in assessments, I think you're completely right that, say, for example, you want to talk about this in one of your assessment center sort of topics, or if you're asked a question by the panel, it could be quite helpful to reference other other platforms. Say we're talking about Google, you could say, oh, well, I understand that Meta is currently going through a similar inquiry, so there's a big focus on this. So then it shows broader knowledge, it shows that commercial awareness, it shows around a picture. And then you can say, well, this could be streams of work for the firm, and this is going to be a growing trend, so this could impact the firm in this way. If this is an area of law that that firm specifically focuses on, has a huge practice in, may even be involved in this kind of work. So I think that is like a major thing to do. And you could do that for other stories as well. If there are sort of similar things, you can bring those in and reference them. Just because you've chosen one particular topic doesn't mean you are exclusively focused on that. If you can bring in other sort of reference points, I think to me that shows a well-researched, well-understood sort of candidate. And that's something that you'll be doing in private practice and as your role as a trainee.
Yeah, thank you so much. Anytime when you can jump in with those insights for interviews and applications, I think those are just so helpful for putting all of this into practice.
Yeah, for sure. And then coming back to the UK point. So again, this is a court case that's been raised in the US by the Department of Justice in the various states that got involved. But I do think that this will still have an implication here in the UK. And I think we may have spoken about the Competitions and Markets Authority in a previous commercial compass, and you can go back and sort of listen to that one in your own time. But the Competitions and Markets Authority is effectively, here in the UK, a body that is the regulator, and it kind of reviews and makes sure that businesses here aren't engaging in anti-competitive practicing. And research has found that it's one of the most active regulators globally. So it's highly likely that they have their eyes on this case. And I understand that it's had sort of a provisional investigation into Google previously, which it raised similar concerns to that of the US. So I think it's only a matter of time before we see a similar finding officially here in the UK and what is going to happen. So it's likely that law firms here in the UK will need to be advising their clients that sit within these sort of big tech spaces, because of course, like Google's headquartered in London, Meta, Amazon, TikTok, they are all here. They all have huge presences here. So it's likely that they're going to need advice on sort of policies on what they should be doing in terms of compliance. And also where we've got these organizations that operate sort of globally, that we need to ensure that the lawyers in the US are working with the lawyers here in the UK to ensure that across the various different regions that we are seeing enforcements of the relevant regulations and rules and compliance with such rules in those various jurisdictions. And again, that requires a sort of multi-jurisdictional approach, working with the departments in the relative sort of firm in those jurisdictions.
Thank you so much. That's really helpful, because I think when you're trying to develop your commercial awareness and you're seeing these news stories that are in other countries, I think it can be hard to see how that's relevant here and how that connects. But clearly there are many ways in which that it is still relevant, even though it is an American case. The other thing I thought to talk about at this intermediate level is just about a little bit more about the kind of work that lawyers do in this space. So when a story like this occurs, then why do law firms care? Then what's the kind of work that they would be involved in? I think you've mentioned some of it already, but I thought maybe you'd want to expand.
Yeah, absolutely. Again, we will be the firms will be focusing on the competitions team will be focusing on, if your client is Google, why this isn't anti-competitive, why this is X, Y, and Z, why this is within the scope of the relevant regulatory remit. And if you're sort of on the side where you are saying, actually, it is anti-competitive, you will say X, Y, and Z. And here in the UK, there are various tests that have to be satisfied and met to say whether or not something is anti-competitive or not. And similarly in the US, although I'm not US qualified, I don't know what it is, so I can't talk on it. But the judge has clearly found that the behavior has been anti-competitive. So that team will be kind of looking through that. The litigation team may be involved as well, because there could be, the court hearing, they would need to be involved, but they could have sort of lawsuits brought against them. We also have sort of the reputational damage side of things and what that looks like as well to manage that. One of the potential outcomes off of the back of this case is that Google may have to kind of divest part of its business. So then we might need the corporate support in terms of how that's going to look, what we're going to do in that space. So again, it's one of those cases that whilst on the surface, it seems like, oh dear, like someone's been anti-competitive, that will just sit within this specific team. Well, actually, when you take that step back, you say, well, this would involve this team, this would involve this team, this person might have to get involved. What's happening here? And again, this is something you'll find when you get into practice and you're a trainee in, let's just say, one team. You will spend a lot of your time liaising with trainees and other members of different departments just as much as your own department, because that's how a lot of these projects, that's how a lot of these matters work. It doesn't just sit with one team. You need to get input from the various experts across the firm, which is a really good thing, because you get exposure to like different angles and how things work, but also it then puts you in touch with different people across business, so you can develop not just your hard skills in terms of like subject matter knowledge and how to do things in drafting, but you also develop those interpersonal skills because you're building a professional network, and those trainees in the various different seats will eventually be your peers. You'll be associates together, senior associates, and eventually partners together. So to start building those connects, those contacts, to have that go-to person in the different teams from an early stage is super helpful. And it can just kind of make you feel more comfortable navigating that space in the project management side of things.
Nice. Thanks so much for outlining that. I think it's always really valuable for our audience to gain these insights of how these things actually work for real within the law firm and how different teams work together. I also think it was really helpful that you identified not just legal areas that are engaged here in those kind of departments that would be involved, but then you also, for example, talked about reputational harm and how that's something to think about too. So I think that is really useful to identify those kind of commercial considerations that we're thinking about too.
100%. And I'm pretty sure it's Mishcons, but they have a huge presence, and I think Shillings maybe as well, huge presence in the sort of the reputational space. So if that's something that anyone listening is interested in, those are firms to definitely look at, because this could potentially be a case that comes their way. And I don't know who their clients are, but there are firms that are huge in this space. So it's definitely, as we see this kind of stuff grow in presence, and the risk of it kind of going wrong when you get bad press, bad reputation, and the impact that that can have on these huge organizations or huge individuals, then there's definitely like a need for a lawyer. And like firms like Mishkon's, they're huge. So to have them involved on a matter, then I think it just shows the importance of those spaces just as much as kind of any other.
Absolutely. And I think that's one of the more fun things about developing your commercial awareness, I think, as well, is understanding the different kinds of work that go on that you just actually were not aware of yet, and then finding ones you think are really interesting. So I hope someone listening actually has found a newfound interest in this kind of reputation management work. Before we move on from intermediate, I just wanted to check if there was anything else you wanted to add at this level before we go into the advanced level.
I think we're good to move on.
Sweet. So let's go into the advanced level then. Here we're really thinking big picture, long term. How do you use commercial awareness in a way to be a strategic legal advisor for your clients? So I had a question for you. This is, quite a broad one though. It's just about when we're thinking about this story, what are the kind of broader implications that we might see for big tech?
Yeah, I think that as we've said, that there's a lot of big tech companies that are likely in the firing line if they're not already in the firing line in this space. But I think what we're going to see is a kind of a fundamental shift in terms of how a lot of these big tech companies kind of monetize their content, and then we're going to need the lawyers to kind of advise on that, to give them sort of strategy and to say, okay, we're seeing this change, maybe you need to do this. We're looking at perhaps regulatory change. We need to do X, Y, and Z to ensure that we stay compliant with the sort of the regulatory remit, which may change. I think also we spoke on this earlier, Ari, the potential Google having to break up or divest parts of its business, not just be fined by the US courts, but there could also be additional sanctions. I think we're seeing that also with Meta at the moment as well, in terms of like WhatsApp and Instagram, in terms of how and when it bought them and why, and all of the emails and correspondence around that is suggesting that there were anti-competitive practices involved in that, and perhaps parts of those businesses may have to be sold. And I think this is a really interesting stance to take, because I guess my take would be that if you're fining these companies have so much money, unless you're going to fine them absolute ludicrous amounts, which again, these companies have ludicrous amounts, it's like obscene. But if you then sanction them with having to sell off, let's just say like Google Ads, Google's ads business is huge and it makes so much money through that. If it then has to divest that somewhere else, that could have a huge impact. So again, that would be something that the lawyers would need to be involved in and kind of advise strategically on what the impact of this would be. How can we challenge this? What could we appeal? Because if you let's go back to Meta, if they lost WhatsApp, for example, that's a huge angle, not just from a business perspective, but also in terms of data that they gather and how they operate and across the whole Meta suite of products. If Google lost its ad business, what would that then look like for the rest of the business? So it's kind of a different remedy, and it could be quite complex, but it's also very robust, and it would be a very aggressive stance from the US courts. And then you'd have to consider how would that impact the business globally as well, and what would the implications be in the various other jurisdictions, and how would that be navigated, which is obviously a lot to talk about in an assessment center interview, but you can definitely kind of allude to these things. You don't have to go in too much depth and say and give a whole remedial plan in X, Y, and Z. But if you kind of touch on these things, it then shows that you've given it consideration, and that's what would be expected of you as a trainee, to kind of say, oh, I think this might happen, or this could be the implication. And of course, when you're a trainee, you'll have more time and resource to kind of come up with advice and solutions. But in your interview, you don't need to be sort of going way too deep. I think just enough to show that you've given consideration and thoughts around potential implications.
Absolutely. I mean, I think that that's really helpful because I think often when you're starting to work on your commercial awareness, it's easy to just be really focused on the story that you're looking at and understanding what that means for the here and the now. That I do think that advanced understanding is really thinking about what could the outcome be then and what are the implications of that. And like you said, it's not that you necessarily need to know exactly what's going to happen because nobody knows exactly what's going to happen, but it's useful to think about it. The other thing that I wanted to ask you about, and then I think it's otherwise just open for any other advanced insights that you wanted to share, is I wanted to ask you, I mean, this is kind of a niche question, but I think that it is relevant to thinking in an advanced way about giving this kind of strategic advice, is basically what is the relevance of M&A here? And is there something that M&A lawyers need to be aware of related to a kind of situation like this? I think I'm not phrasing that super clear, but I think you know what I mean.
You could. I think 100% that one of the things that was raised in I haven't read the full case judgment, but when I was kind of prepping and reading about it just through interest, is that one of Google's previous acquisitions, which I believe were called DoubleClick, were raised in the case. And that shows that, one, how thorough the investigations will be, and two, what they look at in terms of what's considered anti-competitive. And I don't know how DoubleClick works, but I think it's something ad related. But any kind of lawyers involved in M&A in the future, if you've got a big tech company looking to acquire, I don't know, a startup that's kind of scaled and it's got huge, and it's kind of similar, and it could potentially allow the larger tech company to, in the future, be challenged on any anti-competitive practices and the reasoning why this company has been bought. I think M&A lawyers who will be assisting on that transaction, for if you're either for the buyer or the seller, will need to kind of keep in mind antitrust risks and sort of long-term implications, and just be more mindful of that, to say, in the future, if this big tech company has bought this, what could that look like if it scales? What could the implications of that be, just to ensure that your client isn't buying a company and then could be challenged further down the line. That's a risk that you need to be kind of raising and flagging to your sort of big tech company, to say, you can buy this, but just keep in mind this case. We need to make sure that you're not challenged in the future. This is how we can potentially do that X, Y, and Z. If the regulators come, this is what we need to be able to showcase that we've done and why we've done this. So yeah, it's definitely something, I think, off the back of this case that we're going to see lawyers kind of have in the back of their mind as part of an M&A transaction, for sure.
Yeah, I think that definitely demonstrates that advanced commercial awareness of thinking long-term and strategically, that of course an M&A lawyer would need to be thinking in that way to decide whether this creates a risk in the future and how to avoid it. I also think it's just cool. It's another cool way to outline these connections between different areas of work.
100% agree that it's, when you kind of, those listening step into practice, they'll realize how sort of interconnected so many different things are, and sort of the various different support that different teams require. And it's a really, it can be really fun when everybody's kind of involved on the project and you're sort of liaising with different teams. And again, that's the role that you will have as a trainee, is you'll help, particularly if you're in corporate, you'll be sort of managing or assisting on managing sort of how projects going, what documents we need, what the sort of the checkers looking like, the status of documents, which some people love. I really like, because I'm quite controlling and I like to know what's happening in project managery. So it's a really, really exciting thing to be able to sort of piece together.
Absolutely. Yeah, I love that kind of project management stuff too. I think it's really fun. Okay, so those are actually all the questions that I had. So was there anything else that you wanted to add at this stage before we wrap up?
No, I think we covered sort of any key points that I think is definitely worth noting. Again, this is one of those cases that's going to go on. It's relatively fresh, and it's going to be one that we're going to see updates on over the next couple of months as we head into sort of assessment centre season into the summer. And it's also going to be interesting for those watching to keep an eye on sort of the UK's response to this, particularly if this is an area that you're interested in. This will likely be a key sort of landmark case, so definitely one to keep your eyes on.
Yeah, absolutely. I always love actually taking that second to remind our audience to keep up with the stories as they progress, because there will surely be developments that are equally as interesting. So thank you so much, Henry, and thank you to our audience for tuning in today for the Commercial Awareness Compass. Remember that commercial awareness is not just about staying on top of the news. It's about really thinking about it and understanding why these events matter to clients and how you, as a future lawyer, can provide strategic value to those clients. So whether you're at the beginner, intermediate, or advanced level, please remember to always approach stories with this curious mindset and ask, how does this affect clients? What would a law firm do to help? Because that is the mindset that will help set you apart in interviews and on the job as well. So join us next week to keep building your commercial awareness. And until then, prepare without the panic.
Cheers.